Hi, Assalamualaikum everyone. We are back to the most amazing and fantastic legal news, which is the legal bulletin. So, I'm your host for today's program, which is my name is NURUL HANAN BADARIAH binti MUTALIB, and I brought to you guys two amazing speakers that will together with us to discover the issue today. First is Miss IRYANI binti RIZUAN, and second is Miss ATIQAH DAYANA binti MUSTAPHA. So, before we start, let's watch the news on the facts of the case first.
This is a case about the extended remand in March 2021 by the police to the deceased named A. Ganapati, a diabetic cow's milk seller that has been remanded to help the police to find his brother Suryan in the robbery case. However, the remand was extended although Suryan has been arrested on 2nd March 2021 by the police, and Ganapati also has been turned into a prosecution witness. Viswanathan, the deceased lawyer, also questioned police officer Mazlan Ali arrest of Ganapati on 5th March 2021 in connection with a kidnapping case, although the complainant had retracted his report 2 years earlier. The senior investigating officer said despite the retraction of the report, police still needed Ganapati to complete its probe in 2021. At the remand hearing, Ganapati informed the magistrate that he needed to have a wound near his right ankle treated due to his diabetic condition. Filza, the police officer, testified that Ganapati was brought to Selayang Hospital the following day. However, Ganapati died at the hospital on 18 April 2021, just over a month after he was warded. His family's lawyer claimed that the attending pathologist confirmed that Ganapati died due to injuries to his legs and shoulders while in police custody.
Wow, such an incident happened to Mr. Ganapati. However, before we discuss further about this issue, I give you guys a bit of insight about our scenario today. So, the scenario today talking about the law of laws in the area of trespass to person, which is false imprisonment, and the issue we can see is police custody. So, the parties in this case relating to the two parties, which is first, the plaintiff, the families of Ganapati or the deceased Ganapati, and the defendant is the police officers of the Gombak district. And the counsels for Ganapati's family that involved in charge in this case is RIZUAN. There are two legal issues that we establish from this case. First legal issue is whether the act of police to extend the remand or the detention of Ganapati is lawful. And second legal issue is, can Ganapati successfully suing the police under the false imprisonment and the injuries that causing him to death. So let's start first with Miss Anis to answer the first legal issue.
Thank you, our gorgeous host, Miss Hanan. First of all, I would like to thank you for inviting me to join this great show with an exciting topic to discuss. So, skip to the point. Based on the A. Ganapati case, there are two legal issues that we found. The first legal issue arises is whether the act of police to extend the detention of Ganapati is lawful. So, in this case, the police have extended Ganapati's remand on 5th March 2021 in connection with the kidnapping case, although the complainant had retracted his report 2 years earlier. In the meantime, A. Ganapati, who is a diabetic, has a wound near his right ankle and needs treatment due to his diabetic condition. Regarding this case, to arrest the police must prove if there is a reasonable suspicion existed of the plaintiff's involvement in the offence. We refer to the case of Shaban and others and Chong Fook Kam, where the police arrested two respondents on the suspicion that one of them was driving recklessly. But it turns out that the timber of the lorry hit the windscreen of a car, causing the death of one of the passengers. So the court held that the police were liable for false imprisonment as there was no reason to suspect the lorry was driven recklessly. Therefore, in this case, the police may be liable for false imprisonment because no reasonable suspicion existed as the kidnapping case was retracted by the complainant 2 years earlier and thus make an extended for Ganapati unreasonable. Also, according to Section 117 of Criminal Procedure Code, if the investigation cannot complete within 24 hours, the magistrate may authorize the detention for a term not exceeding 15 days. However, in this case, the extended detention for Ganapati may not be authorized by the magistrate since the kidnapping case was retracted 2 years ago. Next, to show that the extended detention by the police is lawful by looking whether there was reasonable circumstances in which the plaintiff was restrained. Referring to the case of Hassan bin Marsom and Muhammad Hadi bin Yaqub, the judge held that when the police obtained the remand orders, they could not provide the magistrate with sufficient information. So the police could not rely on the remand orders to claim immunity from false imprisonment, as they only obtained those orders by improper conduct. Similar to this case, the extended remand for Ganapati was unreasonable as Ganapati's brother had been already arrested, and to extend the remand for kidnapping case, which was already retracted by the complainant 2 years ago, absolutely not in reasonable circumstances. So next, I will pass to the next panel to discuss on the second legal issue. Thank you.
Thank you, Ms. Anis, for a very deep explanation about the first legal issue. So now we know that the act of police to extend the remand of the Ganapati is unlawful. So let's move to the second legal issue. The second legal issue, which is can Ganapati successfully suing the police in false imprisonment and causing him to death? So first of all, there are 3 elements that we need to prove under the false imprisonment. The first element that plaintiff needs to prove to the court is he must prove to the court that his personal liberty has been restrained by the defendant. So, to prove this element, we refer to the case of Weldon and Holmes office, which this case talks about the plaintiff was a prisoner serving a sentence at Leeds prison. He alleged that the prison officers burst into his cells and were violent against him. The officer then locked him in a strict cell, took his clothes, and continued to subject him to violence. He sued for damages under the thought of false imprisonment. The court held that it is a lawful imprisonment because he was prisoner at the time. To apply in Ganapati's scenario, we can see that Ganapati was restrained by the court due to the remand. However, the extended remand has caused Ganapati to stay longer in the police custody, which is based on the argument of Ganapati's lawyer. It was unnecessary and not due to the valid reason. Due to that fact, it is proof that Ganapati's personal liberty has been restrained. Next, move to the second element. The plaintiff must prove to the court that the restraint was intentional. So, in order to apply this element, we refer to the case of Hanan and Bond, that Hanan went to the office of the Commissionary of the Sea and met Bond, one of the commissioners, who concluded he was not fit to be at large, and telephoned Dr. Adam, signed a car, and stayed the plaintiff for 3 hours until the car arrived. Dr. Adam then examined the plaintiff and decided he was insane. The plaintiff was confined at various institutions for 9 years till he escaped and was found to be sane. The court held that Bond is liable for false imprisonment as the detention to the plaintiff at the offices for a few hours was the direct cause of his confinement at other institutions. To apply in the Ganapati scenario, if we dig deeper into the facts, we can see that the extended remand was instituted by the police in order to make Ganapati cooperate to give a statement for a kidnapping case that was retracted 2 years ago. It was unnecessary as the case was retracted. It is justified that the police is actually having the intention to confine and extend Ganapati's remand. Last but not least, the third element is the plaintiff must prove to the court that the restraint was complete, which means that there is no other way for the plaintiff to escape from that restraint. Based on the case of Jualan Prasad and Barma, the Allahabad High Court held that the arrest of a citizen without any lawful justification is the total restraint of his physical liberty, and the plaintiff entitled to damage for the wrongful imprisonment. So, in Ganapati's situation, yes, Ganapati cannot escape as he was locked in the police custody, and he also suffered injuries at his ankle. As a diabetic patient, we can foresee that if the patient is having injuries and didn't get the right amount of sugar and insulin, it will cause further harm to the patients. Thus, due to the health conditions of Ganapati, we can see that the restraint was complete as he cannot escape from the situation. Then, how about the diagnosis given about the cause of the death of Ganapati which caused by the police custody? So, we refer to the case of N. Indrananda Tambi and Datuk Seri Khalid Abu Bakar and others. So, this case talk about the plaintiff claim arose out of death of her son, Kugan anak lelaki Anandan, who was arrested on 14 January 2009 and detained at the Taipan police station from 15 January until his death, which is 20 January 2009. The cause of death was acute renal failure due to the blunt trauma to skeletal muscles. The second defendant was charged with assault and battery and sentenced for 3 years imprisonment. The plaintiff claimed damages against the defendants for negligence, breach of statutory duties, misfiances of the public office, assault and battery and false imprisonment, as well as aggravated, exemplary, vindicatory and special damages. The plaintiff's claim were allowed at all costs. Thus, in Ganapati's situation, it was fully informed that Ganapati is a diabetic patient. The police should foresee that the consequences that would likely to happen if he didn't get the right amount and immediate treatment due to his health condition. Due to Ganapati's wound and injuries suffered by the disease when he was in remand were likely to be the causal link or the reason that the disease health getting worse. The pathologist also confirmed that Ganapati died due to the injuries to his leg and shoulder while he is in the police custody. This medical report proved that the death of Ganapati was contributed by the unlawful imprisonment that has been instituted by the police officer. Thus, to conclude the second legal issue, we can say that the police will be liable for false imprisonment and causing death to the disease. Okay, we settled the two legal issues in this legal bulletin. Now, we will move to the next section. We will compare the law of false imprisonment with other countries. So, I will invite Ms. ATIQAH DAYANA to say a word about this.
Thank you, Dr. Gorgeous host today. So, I will present the comparative laws of other countries. So, our conclusion of the law of false imprisonment is the provision of one ministry which causes the confinement of a plaintiff within an area determined by the defendant, which is not expressly or impliedly authorized by the law. So, in order to prove false imprisonment, the plaintiff must prove that his personal liberty has been restrained, the restraint was intentional, and legitimate, if the restraint must be complete. In the Article 5, Clause 1, the Federal Constitution provides that everyone is entitled to the right of personal liberty. Also, in Article 5, Clause 2, the Federal Constitution guarantees the right to responsibility of each person to file complaint to the High Court to determine the lawfulness of his or her detention. The Criminal Procedure Code sets out, among others, procedures to warrant arrest, in particular sections 28, paragraph A and 117 of CPC, which define the rights of individuals arrested or detained as well as the relevant responsibilities of the police in the process of arrest. Section 28, paragraph A of the CPC, in particular subsection 4, allows the legal practitioner to have consultation with the individual arrested for a reasonable time. However, under Section 28, subsection A, paragraph A, the police could deny the arrested individual's right to legal consultation if they reasonably believe that fulfilling his right could result in outcomes which may jeopardize the case. In addition, Section 117 of the CPC, which relates to the procedure, where the investigation cannot be completed within 24 hours, allows for the extension of the detention period of the accused individual. In particular, SOHATA is concerned about the alleged abuse of human procedures and denial of the right to legal representation by the police during the process of arrest and detention. According to some of the complaints raised by SOHATA, it is alleged that the police had misused Section 38, paragraph A, subsection 8, and Sections 117 of the CPC to temporarily deny arrested persons' right to legal representation as well as to unreasonably extend the remand period. Under Act 497, SOHACA's functions include the following: to promote awareness of and provide education in relation to human rights. Second one, to advise and assist the government. Number 3, to recommend the government with regard to the subscription or accession of treaties. And number 4, to inquire into complaints regarding infringements of human rights referred to in Section 12 of the Act. Sumatra shall not inquire into any complaint relating to any allegations of infringement of women's rights, which is the subject matter of any proceedings pending in any court or any appeal, or has been determined by any court. So now let's take a look to another country, which is United Kingdom. United Kingdom kind of similar with our country, which is Malaysia, that a false imprisonment can be defined as a complete deprivation of liberty for any time, however short, without lawful cause. So the claimant must prove that they were detained and there was no lawful authority to justify detention. So Section 24 and 28 of the Police and Criminal Evidence Act 1984 shows that the following conditions for a lawful arrest without a warrant are necessary, which are the subject to test. The arresting officer honestly suspected the arrested person was involved in the commission of a criminal offense. Second one is the objective test. Third one is the necessity test. Fourth one is the Section 28 test. This officer informed the arrested person of the fact and the grounds of arrest as reasonably practicable. And not to forget the fifth test, which is the witness worthy test. A warrant of further detention can be obtained from the court for the reason set out above for a further period of up to 36 hours. Extra period cannot be longer than 36 hours, nor can it end later than 96 hours from when detention was first authorized at the police station. So as always, like to put the law of Singapore, that they can really find this as a detention of an accused person by the police so that he has been arrested for allegedly committing an offense. So person is generally in police custody from the point that he is arrested until the point that he is released by police, whether on bail or because the police have not established that he has committed an offense. So in Singapore, normally the police cannot hold the people for more than 48 hours from the time of from the arrest without either bringing the person to the court or releasing that person at the end of the investigation or the 48-hour detention period. If the police have not established that you have committed an offense, then the person will be released unconditionally. So it's stated in Penal Code 1985 of Singapore in Section 359. It is wrongful restraint that is stated whoever voluntarily obstructs any person so as to prevent a person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. So the further explanation can refer to Penal Code 1985 of Singapore. So in conclusion, generally speaking, the law in United Kingdom and Malaysia is similar that the police cannot hold the arrested person more than 24 hours, or else the arrested person proves to be guilty. And while in the law of Singapore, the police can hold you, but not more than 48 hours. So I think that is a bit comparative within other countries that I in these pages now. So I think that's all for me. Thank you.
So as we are discussing false imprisonment, in my view, the thought of false imprisonment protects a person's interest in being free from restraint. False imprisonment does not mean putting the plaintiff under the lock and key, but generally it restrains a person without lawful justification to a particular area and make them believe that they cannot just leave. Therefore, the Malaysian law had imposed an Article 5 subsection 1 of Federal Constitution to protect all citizens' personal liberty. Generally conscious that no person can be detained without lawful justification and that every person has his personal liberty protected until the law states otherwise.
The importance of this decision for the future is we can uphold justice to the citizen and give the hope that the law is actually fulfilling the needs and the rights of the citizens. The police, even though they have power to actually investigate and also to imprison the citizens, they actually cannot use their powers above the laws that we have in our country. So whenever this issue happen, there are cases that involve with the area of police custody, and there are people that have been abused by the police. So we can take action and bring this matter to the court so that our citizens can be happy as their right and their need was fulfilled by the law. So I think that's all for our episode today. We will see again next week in Legal Bulletin.